pleasure to welcome you all today to our second Sentencing Young People webinar in conjunction with the Scottish Sentencing Council. So in January, we co-hosted a webinar with the Sentencing Council the day the new guidelines were released, the day the new guidance came into effect for all Scottish courts. And this received an overwhelming positive response and generated such an interest and valuable discussion that the decision was made to follow a second event up a few months later, and that is today. At this webinar, you'll get to view a new animations, bringing the sentencing guidelines key themes to life, and hear from Dr. Suzanne O'Rourke, Sheriff David Mackey and Kirsty Gillis, on all who spoke at January's event. There'll also be a chance to put questions to the panel during the discussion, so do use the question and answer function. If you'd like to tweet as well, please use the hashtag CYCJ webinar, and we will be recording this event up to the question and answer session, and that recording will be made available to you on the CYCJ website. So now I'd like to just introduce our chair for today, Krista Johnson, who's a solicitor member of the Scottish Sentencing Council. She's a graduate of law from Edinburgh University and specialises in criminal defence work. Along with others, she founded the firm of Martin, Johnston and Soka in 1998. In 2007, Krista became a solicitor advocate in the field of crime and has since enjoyed instruction from a number of solicitor firms across Scotland. And she appears regularly in the High Court conducting criminal trials. Christina has also been a solicitor member of the Scottish Sentencing Council since 2018 and has served on the Council's Sentencing Young People Committee since 2019, as well as being a part-time sheriff. So I'm so pleased, Krista, that you managed to find some time in your busy schedule to join us today. So over to you. Thank you.
Thank you very much, Fiona. Although, as has been said, this is a follow-up to a webinar that was held in January of this year, I'm conscious that some people here today may not have been at that event. So I want to start just by giving you a little bit of background about the Scottish Sentencing Council. It is, of course, an independent advisory body. So I'm sure we'll all note, with local elections pending, that means we are apolitical. The Council was established in 2015 and has three statutory objectives: to promote consistency in sentencing practice, to assist the development of policy in relation to sentencing, and to promote greater awareness and understanding of sentencing policy and practice. The functions of the Council include preparing sentencing guidelines for the Scottish courts, publishing guideline judgments issued by the Scottish courts, and publishing information about sentences imposed by the courts. To date, the Council has published 3 general sentencing guidelines, which apply to all offences. Those form a framework for all sentencing decisions in Scotland, and of course for future guidelines that may come out on specific offences. The first of these general guidelines on the principles and purposes of sentencing came into effect in November of 2018. And that guideline sets out the core principle that sentences in Scotland must be fair and proportionate, and the purposes that a sentence may seek to achieve, including in no particular order, are protection of the public, punishment, rehabilitation of offenders, giving the offender the opportunity to make amends, and expressing disapproval of offending behaviour. Our second guideline was the Sentencing Process Guideline, and that came into effect in September of 2021. That guideline sets out an 8-step process explaining how courts arrive at sentencing decisions and the factors which may be taken into account in doing so. This includes how courts should assess the seriousness of an offence with regard to culpability of the offender and the harm caused, and of course, including the impact on any victims. Both of these guidelines apply to the sentencing of young people, and that means that they must be read alongside the subject of today's webinar, which of course is the Sentencing Young People Guideline. As a general guideline, of course, the young person's guideline applies to all offences, but its scope is more limited than the first two because it only applies where the person being sentenced is under the age of 25 at the date of their conviction. The guideline was developed over an intensive period of research and engagement, which, among other things, included direct engagement with victims and survivors' organisations and focus groups with young people aged between 14 and 25. A full public consultation was held in 2020, and the guideline was approved by the High Court on the 9th of November of last year and came into effect in all Scottish courts, as I'm sure we are all aware, on the 26th of January of this year. One of the Council's aims in developing the guideline was to increase public knowledge and confidence by explaining why the sentence of a young person requires a different approach from the sentencing of an older person, and what additional factors need to be taken into account in so doing. I think the guideline itself achieves this aim, and I would encourage anybody who hasn't read it to do so. It was very carefully drafted, of course, to be a concise and accessible document for all. But the Council must do more than just publish guidelines in order to achieve our statutory objectives, because one of them is to promote greater awareness and understanding of sentencing policy and practice. And it's that objective that requires us to carry out a range of other actions, such as this very webinar today and the earlier webinar in January, which allows us to reach wider audiences, that's all of you, and to draw on the insight and expertise of people from out with the Council, such as our very expert speakers today. The focus of the webinar in January was therefore accordingly on presentations by three expert speakers who I'm delighted to say have come back and joined us again today. And they are, as we've heard, Dr. Susanna Rourke, Senior Lecturer in Forensic Clinical Psychology at the University of Edinburgh, retired Sheriff Mackey, and Kirsty Giles of the Scottish Violence Reduction Unit. In January, they each spoke about one of what we consider to be the guideline's three key themes: maturity, rehabilitation, and the need for an individualized approach to the sentencing of a young person, taking into account, among other things, the impact of trauma and adversity in childhood. Now, that first webinar was highly popular. We were delighted with how it went and how well attended it was. And it stimulated a great deal of discussion, which is always very rewarding to see. One of the purposes then of today's event is to provide an opportunity to reflect on the presentations by our expert speakers, and to give you an opportunity to put questions to them and to members of the Council's Sentencing Young People Committee. But the webinar also has another purpose, one which answers in part the question which is posed in the title of the webinar, Sentencing Young People, What Next? For our part at the Council, what next means taking further steps to raise awareness and understanding of the guideline. And as part of that, I'm delighted to say that we are premiering 3 animated videos that we've developed to explain the guideline's key themes. Now, you didn't think you were coming to a premiere today, I'm sure. Let me, before we play them to you or show you them, let me talk a little bit about why we decided to make animated videos. Considering what further steps the Council could take in order to publicise the guideline and raise awareness, it became clear that there were a number of advantages to preparing videos. Firstly, it's undoubtedly the case that a visual message may have more force or convey more nuance than a simple message stated in words. Equally, it's possible to take a complex text and convert it into straightforward visuals. And this was especially appealing to us because the guideline is informed by what I'm sure we all recognise as highly technical scientific evidence about cognitive development, and the average layperson may be unlikely to fully grasp such issues if it were just the written word. Secondly, videos can be viewed and shared widely online, as we all know, and therefore may reach a wider audience as a result of that, particularly those in secondary schools and other educational establishments. We felt that well-designed videos might be an appealing gateway into the guideline and the wider issues that it addresses. And thirdly, while the guideline has generally received very positive reactions since its launch, the public consultation revealed that its purpose and the legal framework surrounding it were not always well understood by individual respondents. Some aspects of the guideline have been considered controversial in certain quarters, so we felt that the videos would be an effective way to try to address those issues. So we therefore decided to develop 3 short videos on each of the guideline's key themes. And I think it's fair to say that we're very pleased with our end results. The first that you're going to see is the one on the theme of maturity. This, of course, is perhaps the most contentious and least understood part of the guideline. For many individual consultation respondents, we're concerned the definition of a young person as somebody who's under the age of 25 at the date of the plea or of the date of the finding of guilt. The Council, of course, takes an evidence-based approach to the development of all its guidelines. We decided on this definition on the basis of a systematic review of the current neurological, neuropsychological, and psychological evidence on the development of cognitive maturity in young people, which was carried out on our behalf by the University of Edinburgh. So what we've tried to do is to distill this rather complex and highly technical evidence into an informative and accessible video which explains why maturity is relevant in sentencing those up to the age of 25. Now, here we go, Charlotte. Let's hope we're at the whim of technology. I'm hoping everybody's going to be able to see and hear this video when we play it. It may be that it's better on full screen and you might want to put your volume up, get your popcorn out and hopefully enjoy it. Over to you, Charlotte.
The Scottish Sentencing Council has published a new guideline to help Scottish courts with the sentencing of young people under 25. This requires courts to consider a young person's maturity during sentencing. Why is this important? Leading research on maturity has identified 3 key stages in brain development. The first 2 stages occur around the ages of 12 and 18. The third and final stage involves emotional maturity. This is where an individual gains more self-control. They also become more able to understand the consequences of their actions. Evidence suggests that some people may not fully develop these features until around the age of 25. Trauma and adversity can also affect brain development. Young people who are not fully mature are more vulnerable to negative influences and may take more risks. This can sometimes lead to offending behaviour. As a result, young people may be less to blame for their actions than older people, but they are still accountable for the harm caused to any victim. The court has to consider the intellectual and emotional maturity of the young person at the time the offence was committed, so that when deciding an appropriate sentence, we can help young people to move away from offending behaviour leading to safer communities for everyone. To find out more about the new guideline, you can visit our website or email us at sentencingcouncil at scottcourts.gov.uk.
Thank you, Charlotte.
Sorry, it's David Ross here from the Secretariat of the Sentencing Council. I can maybe just introduce the next video while we're waiting for Krista to join us.
Oh, if you could, David, that would be great.
Thank you, David.
Yeah, the next video is on the theme of the individualised approach. So the guideline requires the court to ensure that it has sufficient information to assess the maturity of the young person and to identify and impose the most appropriate sentence. It goes on to say that this might include information about a number of things, such as physical and mental health, or speech, language and communication needs. Of particular relevance is the need for courts to obtain information, where appropriate, on trauma and adverse childhood experiences, due to the impact that we know such experiences can have on brain development and behaviour. So this video attempts to explain the impact of such experiences and why it's important that the sentence imposed by the court takes account of the particular and individual circumstances of the young person. Charlotte?
The Scottish Sentencing Council has published a new guideline to help Scottish courts with the sentencing of young people under 25. It requires courts to take an individualised approach when sentencing young people who have committed offences. This means that the specific circumstances of each young person will be taken into account when weighing up their sentence. Deciding the most appropriate sentence for a young person can be complex and challenging. Many young people who commit offences have suffered adverse childhood experiences, such as domestic violence, neglect, or abuse. They are also more likely to have been in care or to have experienced trauma, such as the death of a loved one through addiction, violence, or suicide. Research shows that experiences such as these can change the way a young person develops and affect their mental health. This can be part of the reason they commit an offence. Because of this, it is important that the sentence given to each young person takes into account their personal background and circumstances, as well as weighing up the seriousness of the offence, including the level of harm caused to any victim, so that we can address the underlying causes of offending behaviour and create safer communities for everyone. To find out more about the new guideline, you can visit our website or email us at sentencingcouncil@scottcourts.gov.uk.
And I may be back.
Ah, good. Krista, we can see you okay now, so it seems that you've joined after that glitch. We did say that there would be some technical gremlins today, but hopefully that's them being seen off site and you are good to go.
Excellent, that's good. And I take it that the final video is about to be played, is that correct?
Yes, I've got that all queued up and ready to go.
That's excellent. Well, sorry about that. The final video is on the theme of rehabilitation, reflecting the evidence on cognitive development. The guideline says a young person will generally have a lower level of maturity and a greater capacity for change and rehabilitation than an older person. For this reason, the guideline states that the rehabilitation should be a primary consideration when sentencing a young person. This doesn't mean that other purposes of sentencing, such as protection of the public, don't apply. However, the Council believes that the courts should give additional weight to rehabilitation when selecting a sentence in order to help young people move away from offending. And the video will explain why. Charlotte.
The Scottish Sentencing Council has published a new guideline to help Scottish courts with the sentencing of young people under 25. One of its main priorities is the rehabilitation of young people who have committed offences. Why is this important? When a young person commits an offence, they must face the consequences of their actions. But some sentences, such as short-term prison sentences, can have a greater impact on young people compared to older people. That's because young people may still be developing. They are also less likely to have things like a secure job, a place to stay, or stable relationships. This can make it harder for them to rejoin the community after serving a sentence. Young people also have a greater potential to change and to move away from offending behaviour than older people. So sentences which prioritise rehabilitation, such as community payback orders, can help reduce the likelihood of further offending. And by prioritising rehabilitation where appropriate, we can prevent more people from becoming victims of crime and create safer communities for everyone. To find out more about the new guideline, you can visit our website or email us at sentencingcouncil@scottcourts.gov.uk.
Thank you very much, Charlotte. Success, I think, in playing these. We intend to publish these videos eventually on the Council's website, Twitter and YouTube accounts. Would be more than happy to hear your comments if you'd like to get in touch with us about them. I hope you found them interesting and helpful. I think I maybe saw some of the comments in the chat bar. We also hope that you will share them when they're available and make use of them in your professional lives, just as you feel appropriate. I think there are, for example, some modern studies teachers that will be with us today, and they might consider that the videos would be a good learning tool. You've seen the videos. I'm pleased to say now we're going to turn to our panel, Dr. Suzanne O'Rourke, Kirsty Giles and David Mackey, who will miraculously appear on your screens. I'm not sure I've quite got Sheriff Mackey yet. I thought, there we go, a full house. We thought it might make sense if I spoke to each one of our guests in turn so that we could reflect on the key theme that you spoke about at the last webinar in January. And then perhaps ask for some thoughts on what might come next in that particular area. I wonder if we could start with you and the theme of maturity, first of all. By way of introduction, Suzanne, as I said, is a senior lecturer in forensic clinical psychology at the University of Edinburgh. She has an undergraduate degree in psychology, a PhD in clinical neurosciences, and she subsequently undertook her doctoral training in clinical psychology in Edinburgh. Post-qualification, Suzanne has divided her time between State Hospital and Carstairs, leading their neuropsychology assessment and rehabilitation service, and the University of Edinburgh's clinical psychology doctoral programme. Having spent many years being split equally between the two roles, I understand Suzanne's recently moved to be primarily based at the university, although she does continue to contribute to the State Hospital one day a week as a consultant in forensic clinical and neuropsychology. Suzanne was also the co-author of the Cognitive Maturity Literature Review, which was commissioned by the Sentencing Council and which informed the definition of a young person in the guideline. So we're delighted to have her. Suzanne, perhaps just to kick off, you've seen the video on the matter of maturity, which tries to distill this complex neuroscience into something that a layperson might understand. It's sometimes misunderstood that what the council is suggesting is that young people under 25 don't know right from wrong. It may be clear to me, having dealt with this for some considerable time, that that's not what the guidelines about, but really more to the fact that young people can't control impulses or think about consequences as well as older people. Are you able to just talk a little bit about that and clear up any of the myths?
Thanks, Krista. I think you've probably answered most of the question. I can completely see why someone might get that impression, and I agree with you. I don't think that that's what the guideline's actually saying. It is, of course, important to say at the outset that there are some individuals with intellectual disabilities for whom significant cognitive impairments make discerning right from wrong more difficult, but this would be the exception. Typically, young people know the difference between right and wrong, but they may struggle, as you mentioned, to act on that knowledge in the same way as someone who's reached full maturity. So the report highlights that with more sophisticated brain imaging, we now know that adolescence is typified by biological drivers towards increased reward, novelty, and sensation seeking, particularly in the context of peer influence. At this age, the potential rewards or benefits of an action are even perceived as more attractive. And this sensation seeking can lead to risk-taking behaviour, such as drug taking and offending, or perhaps more prosocially, an interest in extreme sports, for example. So what adolescents and young adults find difficult is that just as this drive towards sensation seeking is at its height, the very areas of the brain that can help young people consider their actions, inhibit their behaviour, and plan appropriate behaviours are playing catch up, essentially. Adolescents are hardwired to seek excitement and to take risks to achieve goals that seem all the more desirable, but their impaired decision-making can lead to high-risk strategies to meet these goals. There can be exceptions, of course, but it's often that they lack the ability to pause and consider their actions and weigh the consequences. So my perception is more that the guidelines are trying to highlight these developmentally normal difficulties so that the courts can take them into account rather than implying any difficulty telling right from wrong as such.
All right, so I suppose in some respects, some of the traits that we might identify even within, well, with teenagers that we know, dare I say my own, it turns out there's actually a scientific explanation for some of the behaviour that's less acceptable or pro-social.
Absolutely. And if you think about it, there's probably quite an evolutionary drive towards that it's important that young people have the confidence and the drive to go out and, find, new places to be, new people to be with, new influences. And that would have been important from an evolutionary point of view, just exploring other options and separating from your original family. So it does serve that, but it does mean that there's this mismatch of time when these drives are really strong and we haven't quite got all the tools that we need to control them.
All right, and with maturity comes development of other parts of the brain that assist in being able to control those impulses.
Absolutely, yeah. Our prefrontal cortex, so the kind of frontal lobe behind your forehead, is the last to mature, and that's the kind of control center that allows you to exercise restraint and forethought, etc.
And up to what age does the science tell us that these parts of the brain do continue to develop? Does it stop dead at 25? Do they
No, absolutely not. In fact, there's some evidence that kind of starts to kind of look towards the 30-year mark. But I think it's important not to get bogged down too much in exact ages. I think it's quite a fluid concept, and more the idea of thinking each person as an individual and just reflecting, looking at their behavior. Does this look like somebody who's reached full maturity but has carefully planned an offence over a matter of weeks, or does this look like somebody who was being immature, risk-taking, seeking excitement and new sensations, and didn't really stop and think about their actions before they committed them? So I don't think we should get too bogged down in an exact age. Everyone's different.
All right. Another point that's been made about the guideline is because young people are able to make other very significant decisions in their life, such as to marry, decisions about who to vote for, they can learn to drive, and so on, at ages obviously younger than 25, that the guideline should have reflected a younger age, and people go to 18 and 21 because culturally and socially these are important years within our society. And alternatively, and perhaps less commonly, it's been suggested that young people shouldn't be allowed to do any of these things if they can't be trusted, as it were, until 25. So are you able to help us through that mire of difficulty?
Yeah, I think absolutely. I think superficially it does look like there's a mismatch, but actually I think when you reflect on it more, we're not really comparing like with like when we think about these sorts of things. So having a teenager myself, I have to say the idea of them doing any of those things in the next few years, it fills me with dread and anxiety, but that's beside the point. But to vote, marry, or even learn to drive, you have to undergo a process to register in your intention to do these things, and in the case of driving, to take a test. So while arguably there are still aspects of impulsivity, particularly with driving, we have processes in place as a society that ensure that at least some thought goes into these actions. So there are kind of built-in protections. But notably, some jurisdictions like New Zealand, for example, do take cognitive maturity into account with a staged approach to getting your driver's license that differs for those under the age of 25. So they're really thinking about the science there. Importantly, I think, though, also voting, driving, or getting married, rather than being sanctions, are kind of positive privileges that we as a society choose to grant young people. And there is perhaps a discussion to be had about whether these should be reviewed. But I'm not going to get into that now, but in contrast, the sentencing guidelines are asking us to consider the harms commonly associated with prison. So kind of flipping the coin there, which may result from developmentally normal limitations in our ability to inhibit our impulses or think about action. So it's trying to protect people, one's giving young people privileges and one's trying to kind of protect them, I would suggest.
Thank you for that. I wonder if just finally you might talk a little about, I suppose, next steps, about future developments in research into cognitive maturity that could be relevant in judicial contexts.
Yeah, absolutely, Krista. I think there are lots of exciting developments that we could consider in Scotland. And the one that jumps out to me is that a number of jurisdictions are trying to adjust their court processes to support individuals where brain development has been impacted. And you could argue people haven't reached the full level of maturity and ability that we anticipate for someone. A significant proportion of those will have an impaired ability to engage with court processes are those with fetal alcohol spectrum disorder, or FASD. And I think that's the one condition that's really going to come to notice over the next few years. FASD can occur when the developing fetus is exposed to alcohol and is conservatively estimated to affect between 3.5% and 5% of the general population. But some studies have found near half of some forensic populations are affected. So FASD is associated with wide and varied range of significant cognitive impairments that can affect both the individual's capacity to desist from offending and their ability to engage with the court and the sanctions it imposes. So remembering to attend court-mandated appointments, for example. So in Manitoba, there now exist, in Canada, there now exist specialist FASD courts that are conversant with the condition and provide mentors to help individuals to engage appropriately and avoid charges related to things like non-attendance. So they have specific courts where they divert individuals with this diagnosis and that only deal with this diagnosis. So there are also diversion programs available to the court and additional support after an individual who's affected by the condition is released from prison. Importantly, there's a really kind of strengths-based approach which aims to build on the client's abilities rather than just focusing on the difficulties they experience. So although in Scotland we do have the option of supporting individuals through the court process, the process itself remains the same, and very rarely is someone declared completely unfit to plead by virtue of cognitive impairment in this country. So I do think there is a question mark over how well the system is working, and that's something that we might want to look at and consider. And on a personal note, I might suggest that while Manitoba, I'm in awe of them creating these specialised courts, there is an argument to have specialised courts that run the gamut of all people who have had difficulties reaching cognitive maturity rather than those with a particular disorder.
Thank you. It sounds to me as if it's something that feeds into this concept that sentencing should be an individualized approach. Absolutely. And it should be tailored to as much as possible the individual who presents to be sentenced.
Absolutely.
Thank you.
Spot on.
Thank you very much indeed. May I turn away from you and ask some questions of Kirsty Giles now. Hi, Kirsty. Kirsty is a psychotherapist specialising in children and young people. She's a trainer and a project manager working across Scotland to reduce violence and within the Scottish Violence Reduction Unit. Kirsty is also a member of the Trauma Aware Law Team who work to improve the justice system for both the staff and clients involved. And she is a mentor for the Inspiring Women in Leadership project in Scotland. We were just discussing there this individualized approach, and the video that we saw obviously deals with that, such as, and with matters such as adverse childhood experiences, trauma, experiences of being in care. And we're aware now, much more, I think, that these are common to many young people who commit offences. I'd be interested in your thoughts about perhaps what might be done at an earlier stage to prevent children in the first place ending up in the criminal justice system, as opposed to having to recognise the difficulties after the event. So if you're able to comment on that, thank you.
Yeah, thanks, Krista. Yeah, absolutely. I think for us at the VRU and my job as a psychotherapist, I would be so passionate about a whole system, whole family approach. I think we have to get better at working multi-agency. When we speak to police officers and staff in children's care homes, children are running away and running home, regardless of what happened at home. Children are incredibly forgiving, and we are born innately with a need to attach, and we will seek attachment. And I think that if we don't do a whole family approach, we will still see this constant intergenerational cycle of trauma. So I believe a whole system and a whole family approach would be the biggest success. And I think we talk about poverty in this country, and we often link poverty to money. And I think that we know that poverty is a massive issue now, potentially more than it has been in a long time. But one of the major issues we have in Scotland is actually poverty of relationships. And I think if we were to move to a place where we were able to understand that we have to focus on what was missing when there was adversity in childhood, and what was missing was the existence of a safe, consistent, positive, boundaried adult in a child's life. And I think we all have a responsibility to be that and do that, regardless of our role. And we have a corporate responsibility and a parent responsibility to do that. I think the power of language is really important. We often assess risk when we should be assessing vulnerability. We look at deficits and problems when we should be looking at strengths. And I think it would be really important to psychoeducate young people if we were able to help them understand the impact of stress and toxic stress. I think we bring them into the picture and we help them recognise that what happened to them in childhood is far more important than what's wrong with them. And I think lastly, we have these amazing opportunities in Scotland. We're very forward thinking. We have the baby box that goes out to every pregnant family. I think we can use that as a resource. We can put leaflets, we can put a QR code on the side. We can ask people if they need help. We can track who looks for that help. And we know the consequences of stress on the baby in utero. So that's where we have to start. We have to start before the baby's even born. I think we've got opportunities to do that, and we have a country that cares enough to do that. So these are some of the things that I think would really help.
I suppose in some way what you're saying is while the courts of necessity do have to try and resolve issues and deal with sentences, there's an awful lot that can be done before anybody ever gets to court, or it's criminalised in a formal way by a court, by having a conviction.
Yeah.
That might be to the benefit of all of us
Yeah.
who are members of the public. You mentioned, I think, at the first webinar, an idea of court navigators. Can you explain to me what is that concept? What are court navigators? What's that about?
Yeah, so I can go through a couple of ideas and things that we do in the Scottish Violence Reduction Unit. One of them is the idea of a navigator. We have them in the community. They started off in accident and emergency services. We now have them in the community. We have them in custody suites, and we're looking at the idea of having them in a court setting. And a navigator for us is someone who's got lived experience of a life of potentially experiencing some sort of adversity in their childhood or childhood trauma, and they've gone through recovery. So whether that be the 12-step recovery program or psychotherapy or lots of different methods of recovery. But the crucial part of a navigator is that they have walked the walk of the lives of some of these young people and the people that end up in the criminal justice system. And it's not supposed to be intensive support, it's supposed to be a navigation system. So navigating them through different services to try and get them the help that they need to recover from some of the adversity that they've experienced. And I think also that two-pronged approach of taking some of the heat off of the criminal justice system, the criminal justice social workers, allowing someone there that's like a mentor and is able to guide somebody into positive destinations, we think would be really successful. And another project we've got is Street and Arrow. It's an employability programme, and what we know from all the research into trauma and adverse childhood experiences, and exactly what Dr. O'Rourke is saying, is these young people, or people in general, don't just need jobs, they need support. Part of our programme is employability. We do wraparound support with parenting classes on self-esteem, self-worth, looking into budgeting, cooking. This is the kind of thing that needs to happen in order for us to actually help people to rehabilitate and heal. And that's how we make Scotland safer for everybody.
Thank you. Can I ask you just one last thing? I consider that my end of the profession, that as a criminal defence lawyer, we are better informed, much better informed than we once were, about all aspects that you have talked about. For example, adverse childhood experiences we're very familiar with. We hear this phrase trauma informed quite a lot in different contexts, and I just wondered what you thought a trauma informed practitioner was, and is it a good thing?
The $1 million question. Yes, absolutely. We're hoping to be one of the most trauma-informed countries across the world, and we're doing a really good job of that. We've got far to go, but we have a government who have really supported the process of that. The NES, National Health Education Scotland, have some brilliant resources online. We can send a link to that, some free training that you can do. So we have real support from top down, which is excellent. For me, trauma-informed is a way of being, and that's what makes it really difficult. If you go to a workshop or a webinar and you learn the science and you learn about adverse childhood experiences, that's an excellent start, but it's just the start. So the best way that I can maybe explain it is through an example. So the Scottish Violence Reduction Unit is part of Police Scotland and part of the Scottish Government. And we see some excellent work by police officers across the country. An example of a trauma-informed practitioner, what this would look like, we have a lot of police officers that say, they arrest someone on a Friday night, there's a lot of aggro and fighting that goes on with the arrest, they're rolling around the floor, there's kicking and punching, and they get this person in cuffs and they take him to the cell. Brilliant police officers will go in, maybe on the Saturday or Sunday, sit at the end of the bed when somebody's a bit more regulated and when they've maybe come off of the drugs and alcohol, which is often a self-soothing strategy for trauma. And the police officer will say, see, the next time this happens, this dance, this fight, can we do it a bit differently? I don't need to necessarily cuff you if there's no aggression. You can with your head held high. That's excellent policing. But a trauma-informed response looks like sitting at the end of the bed and saying, I don't want to do this dance at all. I would love to know how the services could help. There's a lot of drugs and alcohol involved in your life, and I'm wondering if there's something that we can do about that. Trauma-informed is taking the principles of trust, safety, autonomy, collaboration, and saying, I'm in it, I'm here, I'm going to do the best that I can. And if we can get frontline staff to be able to do that, it would be revolutionary. And the first thing we have to do before we ask them is we have to look after our workforce. Adverse childhood experiences are universal. It's not us and them. So once we start looking after our workforce, we can ask them to be kinder, or at least, again, be curious.
Thank you. Thank you, Kirsty.
Thanks.
I will turn now to the third of our guests, and that is, of course, David Mackey, who spoke last time about on the theme of rehabilitation. David's a graduate of University of Edinburgh. He was in private practice as a solicitor and an advocate for some 25 years. He was appointed a sheriff in 2001. For 15 years until retirement, he had the pleasure of seeing me at Alloa Sheriff Court, not every day. He sat as a resident sheriff in Alloa until 2019. Through his work as a sheriff and with charities supporting disadvantaged and marginalised young people, he developed a belief in the power of redemption. He applied compassion and understanding of both victims and perpetrators of crime to his personal judicial practice. In August last year, he was appointed as independent chair of the Hearings System Working Group. So we're delighted that he is with us again. David, we sometimes have heard a criticism of the guideline being to the effect that it rules out custodial sentences for young people. We saw in the rehabilitation video that short sentences can have a greater impact on young people than older people, and that there is to be a prioritization of rehabilitation for young people. There is sometimes criticism that that is going down the route of soft options, and I wondered if you could tell us your thoughts on that very thing.
Yes. Well, good afternoon. I hope you can hear me. Can you hear me all right?
Yes.
I've had some technical difficulties. I'd start by saying that I don't relate to the notion of hard and soft options in relation to offenders, and I'm more interested to know what's appropriate. And sometimes with a serious offence, a custodial sentence is appropriate. It is the appropriate thing to do. As we've discussed, sentencing has more than one objective. Retribution is sometimes one of the objectives. More often than not, rehabilitation and stopping somebody from reoffending have greater weight. But sometimes if somebody, for example, has been involved in assault using a weapon, and it's a nasty assault, then the disposal by the court has to contain a greater degree of retribution and deterrence, and so a custodial sentence might well be appropriate. But we already know that at the summary level, the period of detention or custody is limited, and the worth of a sentence of 12 months or less is always going to be dubious. The idea of a community-based disposal being a soft option is a false idea. It's interesting. Yesterday I was chairing the SOLD conference, supporting offenders with learning difficulties. It's a great little charity which I'm sorry to say I didn't know enough about until quite recently. But although their title is a bit outdated now, referring to people learning difficulties, they recognise that they're actually dealing with a much wider group of people who have challenges with communication generally, and that touches on issues of mental health. And the title of the conference contained the quote, "Send me back to prison." And I've had that. I've had young people saying, I want to go back to prison, send me to jail, because jail was easier. It was safer and easier. There was no requirement to make decisions. Everything was done for you. And that's not to say that prison is an easier option or a soft option, but it's to say that it's not always the right option. With a community-based disposal, young people have to start taking responsibility, and they have choices to make all the way along, even whether to attend the meeting with the social worker, to engage in this discussion with the social worker, to open themselves up to the mirror that's being held up to them about their own failings and what they're going to do about it. And of course, a lot of young people don't comply with their order first time round. But in my experience, trying again often worked. Because being caught up in the criminal justice system by itself is a real bind. You don't have to be sent to prison to feel the disadvantage of being in the criminal justice system. And if you breach your order, you don't turn up for your unpaid work, and you don't come to court when you're asked to do so to explain your failure, then you will be arrested and you'll have a night in the cells and you'll have to come to court, and the whole process starts again. And eventually the message kind of gets through that this isn't going to go away, and this sheriff isn't going to send me to the prison to make it easy, so I'd better just engage. So in short, I could expand a great deal more on that, but when you get into the orders themselves, unpaid work, supervision, and specific programs for domestic abuse, sexual violence, sexual offending, and drug or alcohol abuse, then the programs themselves throw up tremendous challenges for people who genuinely want to address their offending behavior. So the answer is no.
Thank you. Yes, I think if I understand, certainly some of these orders can be very demanding, and perhaps particularly so for young people and young people who are to some extent in chaos within the community. Yeah. To try and
I think it's exemplified. For example, somebody might receive a short sentence of 6 or 9 months, and they'll be released again in 3 or 4 months with probably very little support, compared to a community payback order, which might have a period of supervision of 2 or 3 years, with that support of a social worker throughout. I mean, if you have nothing else in the order, a weekly or fortnightly meeting with a social worker who's going to talk things through with you and point you in the right direction and help you with filling forms, that sort of thing, is there. There's one of the things that came up at that conference yesterday, that a 6 month period of supervision wasn't long enough for one person. But when he got 3 years supervision, that really helped him. And by the end of the 3 years, he was on top of his issues. So that's a good example of how of the difference it can make.
Yes. Can I ask you in terms of alternatives, restorative justice? Can you talk a little about that? I think in some respects you've been championing it for perhaps a little while.
Yes, I can actually talk for hours on it, but I'll confine myself. In Scotland, well, there is a real head of steam building up behind the introduction of restorative justice practices. I commend everybody to look to download. You can get it online from the Scottish Government website. Download the guidance for the delivery of restorative justice practice in Scotland, which was published in 2017. And there you will find not only the guidance, but one of the clearest expositions of what restorative justice might mean within a criminal justice setting. Most commonly in a criminal justice setting, we're talking about a group conferencing type of restorative justice process where the person who has caused harm or alleged to have caused harm will be brought to a meeting with the person harmed. Very often they'll each have a supporter, and also present at the meeting will be an independent facilitator. And usually in a criminal justice setting, somebody who has to tell the story. In New Zealand, it's the police officer. In Scotland, it might be the procurator fiscal, or it could be anybody independent who can tell the story of what happened. And if the person who's allegedly caused the harm says, yes, I did that, then a really serious and important conversation can take place, during which the person harmed can explain the impact of the behavior, what it's meant to them. The person who's caused the harm can gain a better insight as to the impact of their behavior. And it fits in with everything we've been talking about young people maturing. If they begin to see the consequences, the real consequences of their behavior. And sometimes it can even lead to notions of reparation or making good. And all of these elements won't happen in every single case, and every single case may not be suitable for restorative justice, but it would be good if we got ourselves to a point that other jurisdictions have, at which we were able to offer parties the opportunity of a restorative justice process. In Scotland, the Community Justice Scotland have been charged with delivering the rollout of restorative justice processes in Scotland by the end of next year, 2023. They published an action plan in 2019. Again, you can download that. You can see it. Go onto their website, the Scottish Government website, and you'll find that. And they're well ahead with their preparations. The important step we haven't been able to take yet is to actually introduce restorative justice practices into court. Back in 2017, 18, when the guidelines were published, I personally saw that as a green light to do something about it, and started a little initiative in Alloa, which is now quite well advanced. We have a group of social workers who've been trained in restorative justice facilitation, not so that they can act as facilitators, but so that they can identify suitable cases and make recommendations to the court for a restorative justice process to be allowed. And the model that we've been developing is not the perfect model, and it's supported by SACRO, who are the one organisation in Scotland who are really delivering restorative justice in any form, mainly as a diversion at the moment. And there's a lot to be said about restorative justice as a diversion from prosecution within the criminal justice setting. But SACRO, the criminal justice social work departments in Clackmannanshire, have a proposition, and they've reached the point where they simply need to identify cases and, with the permission of the court, introduce them into the process. That last step of getting the permission of the court is proving to be a bit more of a hurdle than we anticipated. And I think that this comes back to a topic that I've addressed in a different forum, of giving confidence to the bench, to judges, to sentencing judges, to make use of the resource of restorative justice. I hope that when Community Justice Scotland finish their work, that will be part of the delivery. But I think when judges feel that they're having to innovate to do something, some feel more comfortable than others about doing that. And so I think there's work to be done in terms of introducing appropriate regulation in our Criminal Procedure Scotland Act, and making room for a restorative justice process within our scheme to normalise it, as has happened in many other jurisdictions. In many ways, we're a bit behind the curve compared to some other jurisdictions on restorative justice. I can go on for hours.
That's very interesting. Thank you very much, David, Mackey, as ever, full of empathy and compassion, as well as great information. I'm going to, sorry, carry on.
I just think very, very quickly on this individualized approach. There's another side to it that we haven't highlighted enough, that sheriffs, social workers can help young people who got caught up in of conflict with the law to get to a point of wanting to address it. We mustn't leave it, mustn't expect them to stop offending or to be better citizens, but we can catch the wave of their maturity and help them get to a point where they want to. And the work you can do in that area is tremendous. It's what we did at Venture Trust. It's what Venture Trust does, is to take people for 10 days and just open their minds to a better way. But again, I could talk for hours on that, but I thought it was just worth making that point.
Yes, yes. Well, it's maybe a lot to expect people to change very significantly. We've all encountered difficulties in doing that in our own lives, going from one situation to a better situation. So we should have patience, I dare say, for all who appear in our criminal courts. All right, that concludes the panel discussion with our